section of the matrimonial property system. The last 2 weeks, we were talking about the variable consequences of a civil marriage, and we spoke about marriage in community of property. We spoke about marriage out of community of property and out of community of property, which is divided into three. We've got the out of community of property without the accrual system, out of community of property with the inclusion of the community of property, and out of community of property subject to the accrual system. Today's section, as I said, we'll be talking about alteration of the matrimonial property system. I'm sure many of you are aware that most people, when they enter into a marriage, they really seek legal advice regarding the matrimonial property system that are available in South Africa, and then how they will impact on their marriage. Often you will hear people after getting married, especially after getting married in community of property, they will say they made a mistake, they did not understand how community of property works, and they want out. Many people, what they do is they will file for divorce and remarry afterwards. This is something that is actually common, especially in the Black community, where they don't follow the correct legal process, but the parties just file for divorce, and others they just permanently decide to separate, while others they will file for divorce and then remarry again. But the correct system, or the correct way of changing your matrimonial property system, is what we'll be talking about. Firstly, I think it's important that you become aware of Section 8 of the Matrimonial Property Act, which regulates the court's powers to order an immediate division of the accrual system. Here, it happens, let's say the spouses are married subject to the accrual system, and one of the spouses, let's say they are not growing their estate, and they are negligently administering their estate, while the other spouse is doing everything correctly and their estate is busy growing. Or alternatively, it happens when the parties are marrying out of community of property with the accrual system, and one spouse becomes aware that the other spouse is busy getting rid of their assets in order to develop the state. So under those circumstances, a spouse has the right to approach the High Court in terms of Section 8 of the Matrimonial Property Act and request the court to order an immediate calculation of the accrual system, so that the spouse whose estate is lower, it is they are given a share in terms of the accrual system. When the court orders an immediate division of the accrual system, they do not terminate the marriage. So what happens is the parties, once the accrual has been shared, the parties will continue with the marriage, but then the parties will decide if they are going to continue again being married subject to the accrual system, or they are going to change their matrimonial property system and make it with complete separation of property, or if they want maybe to make it what is the joint estate. That is a separate application altogether, which we will talk about. But what you need to know is spouses who are married subject to the accrual system, they have a right in terms of Section 8 of the matrimonial property system to ask the High Court to order an immediate division of the accrual. Then Section 20 of the Matrimonial Property Act. Here, the High Court has the power to order an immediate division of the joint estate. Here, just like with Section 8, The court will not dissolve the parties' marriage. Instead, the court will order that the parties share the joint estate, share the assets, and also share the debt. This normally happens when one spouse becomes aware that their spouse, they're busy being negligent, and they are getting rid of the assets. And if they don't request the court to order that they be given their share of the joint estate, they may end up not having anything. So the marriage will continue, but the court will order that you, Mr. and Mrs. Z, immediately share your joint estate, and then thereafter they can change their matrimonial property system, whether to complete a separation of assets or to out of community of property subject to the acquired system. These two applications under Section 8 and under Section okay, that's all. I'm trying to mute. Okay, sorry about that. Molebogeng, can you please try and monitor the attendees, and if anybody's mic is on, please try to mute them so that we avoid having to hear unnecessary background noise. Okay, students, I'm sorry about that. Okay, let's continue. So I was saying applications in terms of Section 8 and in terms of Section 20 of the Matrimonial Property Act, they are really used by people, because often when spouses are having challenges, they will either resort to bring in applications in terms of Section 21 of the Matrimonial Property Act, which we'll talk about now, or they will resort to just terminating their marriage. But it is important to know that these are options that are also available to married spouses. Changing their matrimonial property system or filing for divorce is not the only options that are available, especially for spouses or for a spouse who still wants to continue with the marriage, but they are just not happy with how the estate is being administered. Okay, before I continue and I talk about Section 21, does anybody have any questions or any comments regarding Section 8 and Section 20 of the Matrimonial Property Act? Okay, nobody, so I guess that we all understand. Now, Section 21 of the Matrimonial Property Act. When spouses are married, often in community of property or out of community of property, subject to the acquired system, and they are no longer happy with their property, with their contract, the marriage contract, the matrimonial property system applicable to their marriage, they need to bring a high court application in order to change their marriage contract. The first and the most important information you need to be aware of is this is a joint application. If one party or one spouse wants to change their marriage, contract, but the other spouse does not want to change, they cannot bring an application in terms of Section 21. So this is a joint application, and only spouses who have jointly agreed that they want to change, then they can make use of this provision. Secondly, the parties, now we're talking about the statutory requirements. There are 3 compulsory requirements that the spouses must comply with. Firstly, they must have what is known as sound reasons. They must have good reasons for the proposed change. In the case of ex parte Engelbrecht, it was said that the word sound reasons must be interpreted according to their ordinary grammatical meaning. So in practice, normally how the High Courts view this, or how they normally will accept, or whether to give, whether to grant, to allow the parties to change their contract or not. Often the reasons that they will allow are, for example, if the parties will come and say, okay, it was our intentions before we entered into a marriage that we wanted to enter into an out of community of property marriage. Let's say they're married in community of property. We went to a notary, and for some reason, which was not our fault, the notary did not submit the proposed antenuptial contract on time to the DIS office to be registered. If parties just say, you know, we got married, and after getting married, we realized that, okay, this is really not for us. We want to get married out of community of property. Most of the judges at the High Court, they are often reluctant to allow that. They don't see that as a very good reason, because Section 21, it is not seen as a provision to correct the mistake that was done by spouses. So prospective spouses, before they enter into a marriage, they are required to go and seek legal advice and get to understand the marriage contract that are applicable, and make an informed decision before they sign the marriage certificate. So the assumption is, when spouses enter into a informative of property marriage, they did that having knowledge of all the marriage contract, and they understand the advantages and the disadvantages, and they made an informed decision. But we know that in reality, that is not how it works. Often prospective spouses, they concentrate more on the marriage ceremony and less on the legal consequences of or that comes with being married. So you must know, for the purpose of your examination, you just need to know that one of the statutory requirements is that for there to be a change in terms of Section 21, the parties, the spouses, must have sound reasons, must have good reasons why they want to change from their current marriage contract to the other marriage contract. The second requirement is the notice of the proposed change must be given to all, sorry, I made a mistake here. It must be given to all the creditors of the spouses. And this creditors is anybody who's been owed 500 and above. This may also include, let's say, you are getting, a spouse is getting married to a man who has a child with somebody else, and they were not paying maintenance, and now there is a court order, and then let's say their salaries has been garnished. The proposed change must also be given to that, let's say it's a lady, to a baby mama, if I can use the term that is commonly used out there in Soweto, not in Soweto, out there in society. So anybody who's owed or who has a credit which is 500 rand and above needs to be made aware, and they need to be given a copy of this proposed change. So the notice of the proposed change must be given to all creditors of the spouses. And then lastly, the spouses, they need to prove that no other person will be prejudiced by the change. Remember, for example, when you are married in community of property, the parties have a joint estate. And because of that, if they change from community of property to out of community of property, creditors might be prejudiced because instead of suing both of them as two people, they now will only be able to only sue one person. So the parties need to show that no other person will be prejudiced by the change. And for this requirement, it is best that the parties must not have any debt at all, because if they have debt, or if they, let's say they've got debt, they are servicing their debts properly, but the amount that they owe is quite excessive. A creditor at the High Court, the judge might raise an issue that, but if you change from community of property to out of community of property, Standard Bank might be prejudiced, because if you, Mrs. So and so, lose your job, Standard Bank will not be able to come and attach or to garnish the salary of your husband, because you will no longer have the joint estate. So the parties, before they bring this application, they need to make sure that they at least are able to satisfy that they meet these three requirements. Before I continue and talk about the procedural requirements, is there anybody who have any question or anything to say under the statutory requirements? Okay, I'm not seeing any questions. I'm going to take it like everybody understands. Now, the procedural requirements, but you don't really need to know this for the purpose of your examinations, but for the purpose of knowing as future attorneys, advocates, and some of you will be specializing in family law. You need to know this. From the statutory requirements, there are now the procedural requirements. Firstly, the notice. The notice to change must be given to the register of deeds, that is at the deeds office, and the notice must be published in the government gazette and to a local newspaper at least 2 weeks before the applications. And then secondly, the spouses, they need to disclose all their financial information from all their assets and all the debts that they have. And then C, we spoke about it, that the parties must have good reasons why they want to change. And then D, we also spoke about it, the parties must be able to show that no other person will be prejudiced by their change. And then the last procedural requirements in the notice, it must contain the parties' particulars, the address, and the domicile. Okay, any question? Okay, retroactive alteration. Here, these two cases, they dealt with whether when the court grants the order that the parties can change, can the change be retroactive, or it is only for going forward? In the case of ex parte cause, it was held that alteration can be altered with retroactive effect. But in the case of ex parte Ostenaysen, the court held that the court does not have the powers to give a retroactive effect. So even now, at the present moment, in reality or in practice, when the court grants this order, when the court gives permission for the parties to change their marriage contract, they don't do it retroactively. They do it like the parties, whatever you have, if you are married in community of property, the parties firstly have to share whatever they need to share, and then only going forward, will then the new marriage contract will be applicable. The same occurs if the parties want to change from the accrual system and whether to income of property or to have a complete separation of assets. And then under this topic, the last issue is extrajudicial alteration. Here is basically about whether the spouses can change the marriage contract without going to court. Remember, in terms of the MPA Act or in terms of the Matrimonial Property Act, the change can only be done in terms of Section 21 of the MPA Act. And the question as to whether can the parties themselves enter into an antenuptial contract between themselves where they decide, let's say they're married in common of property, they decide that we no longer have a joint estate and whatever is yours, it's yours, and whatever is mine is mine. The question is that binding? And the answer is no. As long as the parties do not bring a high court application, or let's say they bring a high court application and it is unsuccessful, but they themselves decide that we are going to administer our marriage and behave as if we are married out of community of property. That is not binding. Spouses must bring a high court application or they must comply with the provision of Section 21 of the Matrimonial Property Act if they want to change their marriage contract from community of property to out from community of property to out of community of property, or to change the accrual system to whatever new marriage contract that they want to be applicable to their marriage. Okay, students, this was just a summary, but it's basically how alteration of the Matrimonial Property Act actually work. The most important sections are Section 8, Section 20, and Section 21 of the MPA. Okay, that's it from my side. Do we have any questions? Does anybody want have anything to say? Okay, let's start with Mahlatse. Molebogeng, I see your hand. Mahlatse, you can unmute yourself.
Good day. Good morning.
Morning.
I was just because I was writing, you were a little bit fast. I wanted to know the meaning of reactive iteration. Reactive iteration. The meaning. Yes, please.
Okay, it's like going backwards. Let's say, for example, the parties are married in community of property in let's say in the year 2000, and then in the year 2020 they bring a high court. Okay, not in the year 2020 because it's too far. Let's say they got married in the year 2000, and then in the year 2002, 2 years later, they brought a court application to change their marriage contract, and their court application was approved. So instead of if it was retroactive, the court was going to say from the year 2020, we are going to view as if you are married out of community of property. But because there is no retroactive effect, in other words, they don't go backwards. So it's only from 2002 going forward that now your new marriage contract will be out of community of property. But from the year 2000 until 2002, when you were still married in community of property, that community of property will still be applicable, and whatever you needed to share during that period must be shared equally. Understand? So retroactive basically means backwards. So they don't look backwards. It's going forward now.
Understood.
You understand? Okay. Thank you. Maurice? Maurice, please unmute yourself.
Good morning, everyone.
Morning.
Yes, if I get married, customary marriage, And then all those celebration is done. Then after that, I decided to go and have a antenuptial contract. And then I end up not going to Home Affairs. How does that work? Is that antenuptial contract going to be binding or not?
Okay, firstly, let me just say we are going to talk about we are going to have a session about customary marriages, né? But to answer your questions, customary marriages which are validly concluded are automatically in community of property, even when there is no marriage certificate. So before, once you have entered into an unregistered customary marriage, and it is now in community of property, and you go and enter into an antenuptial contract, that antenuptial contract is going to be null and void, because you need to bring in this High Court application in terms of Section 21 of the MPA. So yes, there is no marriage certificate, but that does not mean that spouses can just they can just trick the system, cheat the system. So they can just cheat the system by saying, because we don't have a marriage certificate, now we are entering into an antenuptial contract and going and register afterwards. If you want to get married in terms of customary marriage, but you want your marriage contract to be out of community of property, the best time to do it is before you even pay lobolo. The reason I'm saying that is because with many conflicting case judgments, there are High Court judgments whereby a man has paid either partial lobolo or a full lobolo, and then with some little celebration, not like a complete handover and all of that, those marriages have been declared to be valid and automatically in community of property. So it might happen that the parties can agree that, okay, let's pay lobolo, and then after paying lobolo, we will go and enter into an antenuptial contract and then finish the process afterwards. But the problem now is we now have conflicting case judgments whereby if somebody just pays lobolo and then there's some smallanyana lunch and all of that, some of those marriages will automatically be declared to be in community of property. And there was also this case, which unfortunately ended up not going very further, of the former president's daughter, who firstly entered into a customary marriage, a full customary marriage with the celebrations and everything, and then the parties entered into an antenuptial contract, and then thereafter they entered into a white wedding. And then when they were having challenges, there was now that dispute, because the wife was saying our marriage, the first marriage that we entered into was a customary marriage, and then it was automatically in community of property, which means the antenuptial contract that we entered into is actually null and void. But unfortunately, it never actually ended up leading to a judgment to give us a precedent as to if the parties have a valid customary marriage where they did not enter into an antenuptial contract, and they have a valid civil marriage where they entered into a antenuptial contract. What should happen, because there's two systems, and then there's an antenuptial contract which was entered into in between these two marriage types. But just know that a validly entered into unregistered customary marriage is automatically in community of property. So if you've got clients in future who say, I want to get married and I'm going to start with the customary law processes, advise them, if they want to enter into if they want to get married out of community of property, they must enter into an antenuptial contract before even paying for lobolo. That will make sure that should there be any dispute, at least the antenuptial contract will be able to confirm that they never intended to enter into a community of property marriage.
Okay, because I'm in this kind of situation currently. So what do I then do to make sure that my antenuptial contract is binding?
You bring a high court application. Because if you are now already in a valid unregistered customary marriage, which is automatically income of property, you need to bring a high court application to request the court to change your marriage contract from a commit of property to out of commit of property.
Okay, thank you.
Okay, thank you. Molebogeng? Molebogeng, please unmute
Yes,
yourself.
we have Lerato. Lerato asked, why is it that we, before the application of to change the matrimonial property, the procedure is to publish it in the government gazette or the newspaper? So her question is, why is it they have to follow that method?
Is to bring awareness to anybody who might have an interest or whose rights might be affected by the change. For example, remember married spouses, they live in their house with their children, and then they've got, let's say they've got creditors. They've got debt and they've got creditors. Those creditors, they don't live with them. So if they are not being made aware that there's this possibility of a change which is going to affect us, their rights will be prejudiced. So just like, for example, when a person has died, when you wind up the disease estate, there are publications that needs to be done in order to make the public or anybody who might have an interest and whose rights might be affected to actually be aware. Yes, the spouses are required to bring to make or to bring the notice to anybody whom they own, whom they owe 500 and above. Ne? But over and that, just in case, let's say they have forgotten to bring the notice to one of the creditors, at least those creditors might also see it in the newspaper and also in the government gazette. Ne? Also, can I say that the requirement that it must be published in the government gazette and in the newspapers. This is something that was done long time ago, before the changes that we have now, because I think we are all aware that a high number of people now, they really read newspapers, and a high number of people, they don't even know where to access the government gazette. Understand? But registered financial institutions, I mean, they know all of these things. They've got employees whose job is just to make sure that on a daily basis you make sure that the notices and everything you read, just in case there is something that might affect us. But for ordinary people who might also have an interest and whose rights might be affected, they may end up not being aware. Let's use the example that Maurice was saying. Let's say now Maurice is in an unregistered customary marriage, and then he goes and gets credit from Standard Bank, and he goes and gets credit from Standard Bank, and along the way he loses his job, and while losing his job, or before he loses his job, he brings a court application where him and the wife, they change their marriage contract, and after changing their but they don't bring what is it, this notice is not published anywhere, and Standard Bank ends up not being aware that, you know what, we know that Maurice was married, and we thought our rights were protected, but now suddenly when we no longer receive anything from him, and then we want to sue, and then we are now told that there is no longer a joint estate. Understand? So that will prejudice the creditors or any third party who might have an interest in this. Maurice, please just, I'm just using you as an example. I'm not saying you are somebody who doesn't pay debts and all of that. Please just excuse me. I just used it because you actually asked a very important question, which actually explains the challenges that most people who are in unregistered customary marriages actually find themselves into. But you also, your example also shows that most people, they actually not some are negligent in getting correct information. Some actually leave it up until it's late. Even those who enter into civil marriages, they have the white wedding, they go to Home Affairs, they have the marriage certificates, and once everything is done, it's only then they just ask, oh, we actually didn't want income of property. Now, how are we supposed to change all of this? And I must say that changing your marriage contract, unless if you have extremely good reasons, the court hardly agrees to this change. This is one of the reasons why an extremely high number of people, they just divorce and remarry afterwards, because they're trying to avoid having to comply with the requirements. They're also trying to avoid having to have the the notices published in the newspapers and in the government gazette, because this alteration of the marriage contract is also not cheap. Is something that is also not cheap. So other people think that divorcing, especially now that the people can file for divorce without having to use an attorney. Others just think that we'll just do the divorce ourselves, and then after 3 or 4 months they just remarry again, and they literally have informally changed their marriage contract. And you'll hear from next week, we're talking about termination of marriage. And one of the requirements now when spouses are terminating their marriage is that they need to enter into a settlement agreement. So when they enter into a settlement agreement, they themselves can decide how they want to share, or how they want to divide their estate, even if they're married income of property. If they decide that they want to, each party wants to keep whatever is theirs, as long as that it is recorded in the settlement agreement and both spouses sign, it will be made an order of court. Okay. Maurice, do you have any other question, or is this a historical hand?
Oh, no, sorry. It was a historical, sorry.
Okay. No problem. Anybody else? Tandy? Tandy? Okay, Tandy's hand is down. Anybody else? Tandy?
Yes, can you hear me?
Yes, I can hear you, Tandy.
Okay. Now, I just wanna ask here, if one spouse, say, is in credit bureau, insolvent, is garnished, and the other party is not in those debts, now they are married in community of property.
Mm-hmm.
Now, in order for the other spouse to protect those immovable assets like the house, they decide to go and change the system.
Mm-hmm.
Is it possible for them to be granted that change if maybe they want to just to move from in community of property to out of community of property? Is it possible to do that if the other spouse is in debt?
Okay, to be honest, chances are very slim, because if one of them is already in credit bureau, let's say it's blacklisted, that says that person is unable to properly manage their finances. So they're going to have a problem proving that the creditors are going to be prejudiced. Because if one spouse is good with financial management, that means that if the other spouse now starts to default again with their payment, the creditors can now sue the joint estate, and they'll be able to also attach the salary or the finances of the other spouse. So when one spouse is really, really bad with finances and they're already on credit bureau, I doubt they're going to meet the requirement that says not that party or no creditor must be prejudiced by the change, because it is clear that that change is going to prejudice the creditors.
Oh, okay. So the best solution is just to divorce and remarry.
No, that is what people are doing. That is what people are
Uh-huh.
doing. But in terms of the law, you have to bring an application in terms of Section 21 of the MPA, but your application can be declined. So once the application has been declined, it is up to the parties to decide, okay, how are they going to solve this? Because the other way of solving this is the parties, they work together, they get somebody who's going to help them with financial management, and then they pay all of those debts. And I mean, when you're blacklisted, you're not blacklisted forever. I think default blacklisting is 1 year, and then judgment is 5 years, unless if you pay the judgment debt, then you can actually send the letter of the letter that shows that you have paid your debt, and then you are removed from the credit bureau. So listing is not really that bad the way people are saying it is. It is bad when you are listed and you are still unable to pay your debt. Then hey, it's a problem. But if you are paying your debt, I mean, after a year or so, then you're going to be removed, and then you are rehabilitated, and you're going to get credit again. So divorce is not always the solution. The solution also may be, let's work together and then get ourselves out of this mess.
Okay.
Yeah.
Okay,
Okay.
thank you so
Thank
much.
you.
Okay.
Okay. Anybody else? Anybody else has any question? Ke amogetswe?
Morning, everyone. Are you able to hear me clearly?
Yes.
Okay, so based on the question regarding the anti-nuptial contract, right?
Mm-hmm.
From my understanding to the way you like you were saying that it is always best to either do the anti-nuptial contract before the lobola negotiations. Is that correct?
Yes. Yes.
Okay. Because usually with us, basically speaking of us Africans, what happens is that most of the time we find ourselves getting like maybe the half of lobola is paid, but automatically it's in commute of property, even if it's
Yes.
half of the lobola that's being paid.
Yes. Yes.
All right. I just wanted clarity on that. Thank
Yeah.
you.
You'll see when we'll be talking about customary marriages, a high number of cases at court is actually about that. When somebody says, okay, yes, we paid lobolo, but our agreement was the customary process was going to be the first step towards us entering into a civil marriage. So we're gonna do the customary process, and then do the antenuptial contract, and then thereafter do the white wedding. And we do know that that is how people do it. But the problem is these things are just verbally. They are not recorded. That you know what. Although we are doing the customary process, this is not what we consent. Our intention is not to enter into a customary marriage, but our intention is to enter into a civil marriage. So when there is a dispute, the one who can prove that, you know what, we entered into the customary marriage is usually the one who's going to win. And hence I'm saying you don't have to pay lobolo all of it. Even a certain portion of lobolo, it is accepted. And then when you have a smaller nyana lunch, where you just, you know, you don't even have to slaughter and do all of those things, but a smaller nyana lunch and then exchange of the whiskeys, that alone is now sufficient because there
celebration.
is a court judgment that says the families can actually agree that they are not going to do the handing over judgment. I think it was a Supreme Court of a judgment case, and then I think that is what actually messed up everything, because by saying the handing over process is not really important. That says they can come to my home, pay, if they were asked to pay 20,000, they pay 2,000, and then they bring those blankets. We have got a smaller nana, a lunch, and then with the excitement, you never think of negative things. And the next people, we buy matching traditional outfits. Just say I'm now automatically married income of property. Hence, I'm saying it is advisable to do it even before the lobol, so that should anything happen between the customary law processes and before you enter into a civil marriage, you know that should death occur or should we separate, at least I've got this document that is going to protect my assets, because it is extremely difficult and expensive to prove at high court that what, this is not what I intended. Yes, I can see everything that we did. I mean, we all know the HAP case from the Constitutional Court, where the processes were only done from the female side, but she was declared to be a customary law spouse, married in contempt of property, even though nothing was done from the late husband's side. Understand? So those are the cases that just messed up everything, and because of that, it is better that when your client come to you and say, I want to get married, tell them that, what, if you want to get married out of contempt of property, enter into the antenuptial contract before you do anything else. Just, yes, just so that at least during dispute, you've got something that is going to protect you.
Okay, thank you so much.
Okay, thank you. Anybody else with a question? Okay, student, that brings this to the end of our today's session. We shall meet again next week when we will be talking about the termination of a marriage. If you have any questions, feel free to send us an email, or if you didn't understand anything but you want a one-on-one session, please feel free to send us an email. All the best with your studies. All the best with your studies, and yeah, not just family law, but with all other subjects. Thank you so much, and we shall see each other next week. Thank you. Bye. Bye-bye.
Bye.
Bye.